You're listening to Where You Live with Gene Sullivan.
Welcome back to Where You Live. I'm Gene Sullivan, and I'm broadcasting from the True North Painting Studios. This show is brought to you by American Family Insurance, the Kim Bennett Agency, and Extreme Exteriors. You can count on Extreme Exteriors for expert installation of exterior siding, roofing soffits, fascia decks, windows, and more. With their knowledge and experience, they can design the perfect solution to make your home beautiful and energy efficient, saving you maintenance and money for years to come. Give them a call at 763-441-1334 and tell them Gene sent you. It's time now to hear from the Community Associations Institute. The CAI Minute is brought to you by New Concepts Rental Management. Whether you're an accidental landlord or a seasoned investor, New Concepts Rental Management can advise and guide you through every aspect of the business. Give us a call at 952-922-2500.
Are you a member of the Community Associations Institute? For nearly 40 years, CAI has provided education and resources to volunteer homeowners who govern community associations and the professionals who support them. Visit caionline.org to learn more. The address again is caionline.org. CAI helps community associations board members by providing online resources, in-person training, and hard copy publications written by association management experts. CAI offers community managers professional development, networking opportunities, and a certification program that is established as the industry standard nationwide. Minnesota has its own chapter of the Community Associations Institute to bring resources and tools from community associations around the country right to your home. Visit www.cai-mn.com to learn more and become a member of CAI today. Your community and management company will benefit from your involvement. Join the Community Associations Institute today at cai-mn.com and click on membership.
If you're just joining us, we're talking about this story from Arizona. Earlier this year with the Arizona State Legislature, a particular state representative had a couple of bills that would have an impact on the homeowner association industry. Reading the bills, I thought they were quite good, actually, and I would be in support of them. However, she found out that there was not support at the committee level, and so instead of being able to have those added on to the omnibus bill, which is the large bill that at the end of the legislative session, which allows everything to be cleaned up at once, and the legislature's already gone through the process and all the discussion of all of these various topics. And the omnibus bill is organized as an anthology of sorts. It is all related topics are together. What this particular state representative did, the day before the things went into recess, before the vote, took similar language of what had not passed out of committee and stuck it into an elections bill. And so now all of a sudden, these issues became law. Well, a gentleman by the name of George Staropoli said, "Hey, wait a minute." He said, "This is not fair."
No, stop it! We're playing this game according to Master Jack's rules. Bad form.
That's right, exactly, bad form. And so what we had here is that Mr. Staropoli ended up taking it before the Attorney General. And it was finally decided that by the Attorney General that, yes, you know what, even though there is there is some give and take where a last minute things are added on to bills, this one was probably a little bit more blatant than in other cases. And so they said, the Attorney General in Arizona said, the state is going to not recognize these laws. And number two, we're going to reimburse Mr. Staropoli about the $7,500 that he had in court costs. And I was saying at the beginning of the show, I'm in agreement with this, basically, not because of the ideas themselves he disagreed with, I do agree with, but we both agreed on the same thing, and that was the process wasn't done correctly. When you're in government, no matter what it is, it's imperative that things be done deliberately. If you live in a homeowners association, that's why so much importance, for example, is placed on just the very notion of an advance agenda and a specific notice of board meetings before they take place, and of a notice and agenda of what's going to take place for an annual meeting. And the reason why is that every member in a homeowners association, just like any member of Congress, they need to know what it is that they're really voting on. They need to have the right to be able to say, I want to speak either for or against this. And so that's why it's so important in a homeowners association. And so that's why I was saying from the onset, I don't think that it's necessarily good that the end justifies the means, especially in these cases here, because we're talking about a situation that is affecting the lives of millions of people in Arizona, and people had no idea that this was in there. I mean, after all, isn't that some of what we are upset with already with what's going on at the federal level? We end up having a national health care bill, and didn't one of the politicians say to us, well, we need to pass the bill before we find out what's in it? That kind of idea. We've lost this notion or understanding of how important it is to be deliberate in our laws. Well, what were these laws that were so important that this gentleman, Mr. Staropoli, was opposing? And the reason he opposes them is because he's had, I know, a very bad experience with homeowner associations over the years, and that was the crux of our discussion a number of years ago when we had him on the show. Here were the two laws that this state representative tried to last minute put into effect. One law would have limited the amount of information a homeowners association could request about a renter. So HOAs would be prohibited from imposing rules that would not apply equally to homeowners. So what we had here is that was the case right now, and so we wanted to. This state representative wanted to see that it was okay, and that it was clarified that it is okay for and necessary for a homeowners association to be able to request information and background information about potential renters before they move in. And a couple of things, though, when they talked about this example, one thing I thought was a very bad example and should not be included that a homeowner association asked for. The other thing is a very good thing, and I think a necessary one. The bad thing, they gave two examples of what an HOA was requiring in the state of Arizona. And one association was requiring Social Security numbers of potential renters. I can tell you right now, I can see no reason, no valid reason whatsoever why a homeowner association needs to know that very important information and identification marker on other people. It is not necessary for the well-being of the association. On the other hand, the idea of having a credit report, a criminal background check, those things are good because I think it is important for someone to know whether or not someone is going to be stable in the community. A credit report, you bet. You've got, by virtue of the fact that you have 50, 100 homeowners all linked together and connected at the hips and responsible for the budget financially of this association, you want to make sure that the landlords have renters who can pay. And so having a standard for a credit report, having a standard of what's allowed for a criminal background check, those things are important and should be allowed. The other issue is there was another law that would have allowed homeowner association management companies the opportunity to represent the association in small claims court. This is the law that Mr. Staropoli was really against. He did not want to see management companies that are management association firms that had a relationship with a homeowners association to be able to represent the association or board of directors in small claims court. We can do that in Minnesota. That is something that can't be done and was changed a few years ago in Arizona. They were trying to change this. Well, why? Why are some people against it? The reasoning that people had was they said this in the article. They said property managers should not be allowed in small claims court because they have more experience being there at small claims court, which puts the average homeowner at a disadvantage. Is that really true? Well, with that logic, shouldn't we then probably examine how many times everybody's gone to small claims court before you allow there to be a matchup at all? Because if one other person has gone a couple more times than someone else, my gosh, they're just going to take advantage of someone. I think that's ridiculous. I can tell you right now, I know there are homeowners in some associations that have been to small claims court because of being litigious and contrary a lot more times than property managers that work for me with my firm. If we went with that same logic that the person who's been there more times has a greater advantage, I think you can see. I think the logic breaks down there. But those were the things. Those were the laws that had passed, and the state of Arizona came back and said, no, that is something to be discussed for another day, because why? The process wasn't done correctly. Well, here's a process we've got to take care of right now, and that's go to break right now. Don't go away, though. We've got a lot more of Where You Live after these messages.